That's your prayers. Have you been served with this? Yes.
And then we got down by final final dated the 18th day of July. In this book, it was a day that we think paradox and that it miraculously from somewhere popped up and when they did that, one would think that you find all the necessary things. And not in 1 year, how would they find emotion for extension of time? Just do that. Just so just so so we will not join it because we know that in from branch of care care, what is most likely will just towards the that oh, before the witness, let's inform of the and then they okay, there's some of proof again. So on that ground, we are not any we are saying that this is purpose that we are he is my God. We completed this man, calling for them to bring us back. And we have just
Okay.
which we've gone through a lot. This 2021 modified that we concluded any 2020 if they had allowed us to move our final address by July 20th, for the adoption of this address. However, they appeared and said, oh, well, they are willing to do the matter. And we had no choice for their right here. So that is where we are. But my hope to see that from that date to date, they are simple. Like what we have done prior to that. Let's say like what's finding, then we are at least.
Okay. All right. Before we go further, we see that we now have a virtual hearing now, and apart from that, we have 2 more virtual hearings. Yes, and I think maybe we adjourn this particular one motion. This motion. Yes.
Why this motion
Must be seen. Okay.
not ordinarily, but for the fact that they are asking over the business, also for the fact that they are the court has regularized their we wouldn't have filed a because the witness is coming for us, it's coming to just adopt the side. Now we get in the actual
Okay.
what they can file. And also if they are calling him, if they are calling him to for the purpose of was examining him the record of things we did before, and by law, they must move this motion.
I see what you mean. I see what you mean. Yes. I see what you mean. Yes.
Also, in setting the record, very important. Firstly, we state that we not. And on the second point is that after we came acknowledging that we were as a response to instructed by the defendant, this court has done moving. The extent also that we came introduce our body in this court gave us a cost, cost of 50,000 naira. And over of this cost was paid. After that payment of cost, my lord, I have been the one appearing in this matter on behalf of the defendant. And over Lord, save the date of here. We have always appeared further to filing our statement of and extend time to regularize that process. My lord, from that point onward, when the court has penalized us for having done this case for so long or taking parties back, my lord, we have demonstrated diligence and we always appeared in possible. My lord, even this morning, I told my Lord that I was not at the last stage, but I'm ready to proceed for trial. My Lord, there is no other.
Okay. You can see that the okay. Can see the man looking at me. Yes, so let us do something. Yes, I can see he's ready. He's already ready to for the Zoom hearing. So if you can go through that quickly, and the court will write a quick ruling, then we now go to the matter at hand. Yes. Okay, please call up the case. You know, I was just contemplating whether it will really go on today or not. That's why we haven't. Please call up the matter.
Case number MSS/N/11/11. Sheye Residential Mortgage Bank Limited. To the area of Office of
Sheye is this man that
Yes,
I'm
ma'am.
looking at. Sheye, are you hearing me?
Yeah, I can hear you clearly, my lord.
Very well. Clement is okay. Appearances, please. Yes.
Is spelled A.
Yes. Yes. Okay. Yes. Yes. Okay.
Learning myself, I fight. The Lord will announce our parents, send them
Yes. So,
like two, and Lord, we are ready. But the application is for first month,
it says dated 20.
like,
Okay. Yes. Yes.
first month.
Sorry, excuse me. You say you're not opposing actually.
Only at it.
Okay, you're not opposing. Okay, so you have to abridge all these applications.
I know that moving them.
Yes.
I was removing 10 prayers that contained the place of application paper. And all this local public plan state. You know, also not complete cost. Cost of the cost not a word of station. A lot they have demonstrated diligence from after the
Yes. Yes.
strongly with those topics. In any event of or the online event,
Yes.
then
Come again.
as the first thing, all this on the personal but not the proceeding like the complaint sign up decision.
Okay. Since you've said that, the court doesn't forget. Mm. Okay.
My love number it does not by that first was with just the day I need to they came in, right? Supposed to buy the motion by that of 1 million. Because I mean, came like the court had been the now five. get a point that we have to like, that. So that has nothing to do with this particular case. So council is clearly when the project.
The point is this: I don't just want this issue of cost to delay the smooth going on of this matter. So, like he rightly said, the court knows what to do. Yes. So the application is granted without any objection, and the orders of the court are as spread serially on the motion paper. The court shall make no issue, no order as to cost today. Yes, today. I have underlined today. Oh, yes. Okay. Thank you. So can we start as the matter? Yes. Yes. So the matter is for hearing. Okay. Please swear the witness. How do we swear him? Now, what's his name? Sheye?
Yes, only going to share.
Okay. Are you a Christian, Muslim, or pagan?
I'm a Christian, my Lord.
Okay. Would you want to swear by the Bible or you want to affirm?
I want to swear by the Bible. Any one of the two.
No. Choose one.
Okay, I want to affirm.
Very well. Can you stand up? Stand up from where? Yes. Raise up your hand. Raise up your hand. Yes. Then you can say, I.
Onigbide Sheye.
Okay. Affirmed
Affirm
that
that
the evidence I shall give in this case
the evidence I shall give in this case
before this court
shall
be the truth,
be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Very well. Very well. You can sit down.
Thank you.
Well, he's not swearing, so we can't say so help you God or so help you anybody. So you are now sworn. All
Okay.
the evidence you are going to give must be the truth and nothing but the truth. So
Yes,
listen to your counsel. Yes.
Yes. Witness, for the record, can you tell the court your full name?
Okay. My Lord, my name is Onigbide Sheye Tosin.
Do you understand, Mr. Joshua?
Yes, man.
Do you hear him?
I'm trying to connect my device so that I can also
Okay.
hear.
Please do that quickly so that we are sure you hear him. Yes. Oni Gbide, those should say, okay. Those. Yes.
Yes, witness, tell the court where you reside.
Sorry, it's echoing. You didn't get that.
Please, counsel, put off your so that it won't echo. Go on.
Yeah, witness, what do you do for a living?
I'm currently a software developer.
Where he lives?
Can you kindly repeat your address, where you live?
My address is number 7, Eyowawi Street, Pangrove, Lagos.
Yes.
Do you know the defendants in this matter?
Yes, I know the two defendants. I used to work with the first defendant, Prudential Mortgage Bank, and also the second defendant is the managing director of the first defendant, and it's also my the guarantor of my loan in this case.
Yes.
Do you remember coming before this honorable court 11th day of December 2023 to be posed to additional witness statement?
Yes, my lord.
Yes.
Yes.
If you see this statement, how would you be able to recognize
I can identify it with the signature.
any difference? Confirm to the honorable court if that is the case.
Yeah, yeah, I can see that's that's it. Yes, I can affirm that's it.
So what have you? How have you identified it?
By my signature there, I sign as the.
Okay. Yes.
Would you like to adopt this statement as your additional evidence in this matter?
Yes, my lord, I would like to adopt this as my evidence on this case.
Yes.
Yes. Yes.
Yes, witness in paragraph 9 of your additional witness statement, you make mention of certain email notifications titled initial loan repayment.
Yes, yes, my lord. I mentioned names, the dates of email notifications of loan repayments for the bank. But my lord, I would like to apologize for a clerical error. On the oath signed, it stated on the 25th, but the dates of the notification on the document itself is we have March 26, we have June 26, we have August 26, and also have December 26, 2020.
Okay. Yes. Yes. I'm trying to identify the document itself. Then I will have to see the errors. This 11, 12. Come. I want to get 11, 12, 23. 11, 12. Okay, fair enough. It's first good. Okay. In this paragraph 9. Yes. So, Shea, what did you say happened?
Yeah, I
with the-
stated it was on the 25th of the month stated there, but actually they were sent on the 26th. So it was March 26th, June
Okay.
26th, August 26th, and December 26th of 2020.
All of them are 26.
Yes, my lord.
Yeah. Did you get him? Did you get? Okay. Very well. Yes.
Yes, witness in paragraph 10 of the witness statement of proof. Hope you can hear me.
Yeah, I can hear you.
All right, so in paragraph 10 of your witness statement of proof, you outline the procedure or the process that you went through in printing out the emails, notifications you mentioned in paragraph 9. Is that correct?
Yes, my lord.
That you did what?
In paragraph 10 of
Yes. Yes.
he laid the foundation. First one to stating how to proceed with steps to printing a recipe.
Yes. Yes. Yes, go on.
Do you confirm to this honorable court that the steps mentioned by you in paragraph 10 of the witness statement on oath were the steps that you took in printing out those email notifications mentioned in paragraph 9?
Yes, yeah, I confirmed that. I used my HP laptop, Core i5 as a laptop, and also I used a printer, LaserJet printer, in printing it. And at the time I printed it, they were all in good conditions, and also I printed subsequent documents from it, and they are all in good conditions.
Yes. Yes. Were they ever listed? Were they ever listed anywhere as the documents intends to rely upon? Because it makes it easier.
In our list of witnesses,
Yes.
number 8, printed email notification.
Okay. That was listed on what date?
It was listed there with our file the list of there with our
Okay. Was it dated?
It's dated 9/2/5.
Nine day of March. Okay. We have okay. How many documents did you say? You had four. There's this place you have schedules of documents in a box. Okay, it says number what? That is printed email notifications to claimants. Claimants. Yes. Which else? Okay. Mm. Yes, I can see what you say. Very well. So give me the documents. Let me have the documents. March 25th. Well, actually, council, all of them are prudential loan repayment reminders. So what are their titles? That is that. Those are the titles. Okay. Okay. So, without prejudice to the right of the defense counsel to object to any of the documents sought to be tendered, the following documents referred by the claimant in his sworn evidence to wit: 1. Prudential loan repayment reminder of 25th December 2020. Secondly, prudential loan repayment reminder of August 20th. No, of August 18th, 2020. The third one is a prudential loan repayment reminder dated June 25th, 2020. And the fourth one is prudential loan repayment reminder dated the 25th day of March, 2020. Yes, these 4 documents are hereby admitted in evidence and marked exhibits C1, C2, C3, and C4, respectively. Yes. Okay, these are not the first one. These are not the first one. Already. Then this is C15, C16, C17, C18. So these 4 documents admitted now are marked exhibits C15, C16, C17, and C18, respectively. Yes. Yes. This. C15 to C18. Yes. Can you hear us?
Yeah, I can hear you, my lord.
Yes.
One is for you.
What do you want the court to do for you?
Okay. My lord, I want the court to order the both the first and the second defendant to return my car, Toyota Camry car, taken away from me since 2020 in the condition it was when it was taken. Also, I want the court to order them to return all the funds that were illegally deducted from my account domiciled with the bank, with the first defendant. And also I want the court to order them to release my bank statement, both the loan accounts and the current account bank statement of my account domiciled with the first defendant. And I also need a letter of non-indebtedness, signed by the bank by the first defendant. Thank you, madam.
Okay. Yes.
Yes, my noble lord. I call for the exhibit standard, document standard.
Yes. The little problem we have here is that we discovered we have 3 Zoom trials today, and this is just number 1. So I'm thinking of adjourning this matter and having you cross-examine on the next agenda.
My lord, we are fine with whatever option my lord would have us take.
Council, how do you feel? Okay. Yes. Can you do that? Very well. Register, give me a bit. How do you stand on the 9th day of May? For both of you? What of the week? Yeah. Give me another convenient date for the court. Is it convenient for us? Is it convenient for us? Just
The last time. No. Yeah.
okay, we have to do it again today. But I didn't think today. What date is that? So the 16th day of May. 20. Yes, don't worry. The matter is adjourned to the 16th day of May 2024 for the conclusion of the cross-examination of CW1 and defense. Okay, it's virtual too. Okay. They were virtual too. It's supposed to be by 1.
Thank you, my lord.
Yes. Okay. Mhm. With all these people. Mm. Okay. 28. Mm. Okay. Awareness. Mm. And then I don't
But that day, cancer did not come to court. When the government, cancer did not come to court. Yes, my lord. On the 21st of February is the real date. Cancer for court witness.
Okay.
So we came by 2nd of May.
Okay.
Now my colleagues, instead of endorsing the and also just the other cancers, the cancer said it was not, it did not receive the hearing. It's not prepared. It came from another one.
Okay.
So I didn't make sure
What was the second count?
the payment is here to be paid from another one. We are both here, but one is not prepared.
Mm.
So we just call it.
Lemmas at present. Okay. How about the defendant? How about the defendant? Appearances. Yes. Okay. Yes. 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 Mm. But, okay. 19th March. No. 21st February. Was it? Where were you here for? Okay. On that day, what day? Yes. The second day of May. Yes. Okay. You mean my registrars or the penny who still No, actually, when I tell other council that when I tell other council that the court is still because I look at them and how everybody is getting against the court. It was just now that I had the fact that there must have been a so in depth that but actually instead of the second so to come on the constitution and have it here, I don't know what to have to uh, my staff to the forum so like that the case court is there. But then court cannot sit alone. Have any support. So I don't know what to do. This Zoom pattern we are being controlled from and then we must necessarily after that I feel but then someone will come here to like, I feel their pain. I feel their pains now. So, so you said, I agree with you. I know what you want. So, and for both of you, I always tell counseling before. Sometimes I stop to this. I said, if you know your matter will come up, so if you feel that these people, they've been here for a long time, they're not sure if you're not a strong lawyer, you get up and tell them, oh, this is hard. The court is always mindful of something. Even the person traveling up and down the line. Is he going to testify? Yes. I don't know what to, because even if you don't even, you may not even go on it. Okay. You know, people make mistakes. The mistakes of people are here already. Not to suffer one who are going home late. They do suffer. So I don't know what to do. I don't know what to do for people not to like, can you have a tea with them and take them? The HR is coming for course examination. I did not want to. And they have also have a meeting of and it's not support from the people. Okay. 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 Next time we can take it like this. What this is, after the man is not giving he got to if I say, relative I say, um, my please go and find my second mate. Okay, she now come and take a data. Yes, that's it. So please, so sorry. So, uh, sorry. So the second one, okay, the Mr. Please give them a. Give them, so that my Lord can close up. Give them just to close up. Let me just give them. Okay, yeah. Bring it. When they give them, I close up. When? 16th day of May. So this man is the second witness. Okay. So is he going to be cross-examined? So this matter is now adjourned to the 16th day of May 2024 for the cross-examination of the CW2 and continuation of hearing. Yes. Is he the only witness? And continuation of hearing by Zoom. Do we have any time? Any time? It's going to be by Zoom by 1 o'clock. Okay. Okay, thank you. Yes. Is it the okay? Mr. Temitope. Okay. What you're saying is that he was here before? Yes. Okay. 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 Well, why don't you take the second Zoom hearing? Because this Zoom, if we are cut off, we are cut off. The other one, we can always hear it. Yes. So, but whenever your client shows up, you let us know that is now here. So let us take the second Zoom hearing. Okay. Okay, yeah, join. Okay. Mr. Temitope. Mr. Temitope.
Johanna, good afternoon,
Okay.
Johanna, good afternoon.
Can you hear me?
Yes, I can hear you. Good afternoon,
Temitope.
Johanna. Yes, I can hear
I
you.
can
Good
see
afternoon.
you. Can you hear me?
Yes, I can hear you. Good afternoon, Johanna. Can you hear me?
Good afternoon. You're welcome.
Yes, Johanna.
Okay. Call up the matter. Have we called it up? Okay. Defendants are absent. Appearances, please. Yes. We hear you. Yes. Very well. Yes. That's right. Okay. All right. So what's the business of the court today? Hearing. And you are ready? Very well. Yes. Yes, it has been struck out. Okay. Okay. Apart from striking out the name of the second defendant, what else is affected, succinctly affected by the striking out of the second defendant?
Generally, the
Parties change.
parties is changed. The claims was generally against the first and second defendant. So
Okay.
it affected the claims against the defendant. So the claim will not be just against one defendant now. So it's changed. It's changed.
Okay.
Changed. So we believe that by the rules of the court, within 14 days, they should have filed the amended processes, but they didn't do that. And that's kind of restrained us to respond to their statement of fact or amended processes. We haven't filed yet.
You hadn't filed it before now.
No, we filed previously. So this will be our consequential amended statement of defense and counterclaim.
Mm. Counsel. Yes.
The amendment.
Yes. Mhm.
Five May 3.
Of which year?
25th May 2023.
Yes.
Note again.
Yes.
And when these courts give the order striking out the name of the second defendant, there is no specific order asking us to even amend or to file within that limited time. We just feel like we need the process clean. So that's why we have started a long time ago.
You have amended and you have served them.
Amended, we have filed our application amendments.
And served them.
That's 25th May 2023. Yeah, the issue to copy is fine.
Okay. You were served.
Yes, I confirmed service, my lord. I
So,
confirm.
you have not made any consequential amendment as that order affects your case.
Yes, we haven't filed any after they served us. However, we intend to file the motion, which we have filed, and we've served the Claimants Council, which he said is not opposing. We don't want to bring in the application to change, because the application is for submission of witness. We don't want to bring in the processes with the previous witness, then bring another application to change again. So that was why we didn't file any process. That was the reason why. The process was just brought to the court this afternoon when we filed. So that was a delay in the course of our
Okay,
filing.
your consequential amendment was for what?
Was for the fact that they amended their
Yes.
consequential amended statement of facts.
Okay. Yes.
So since they didn't bring an application to regularize, we could not bring in our application, we could not bring in our consequential amended statement of defense. Because if we do that, we still have to bring another application for change of witness, we will have to file another process again. And we wouldn't want to do that. That was the major reason we didn't file, my lord. That was the major reason.
So the first one is the application to
Substitute immune
no,
witnesses.
not that one. The other one to regularize.
Yes, my lord.
Okay.
They haven't filed at all.
Which you have not filed.
They haven't filed.
Okay. They filed without regular. They filed out of time.
Out of time, yes, my lord.
Okay.
Though there was no order as
I
to
know.
at a particular time to, but by the rules of the
because the court intends to allow them to make an oral application to regularize, and we can take it so that the business of the court can still go on today. You can file that your motion for substitution hereafter. You can still file it.
It has been filed, my lord. It has been filed.
It has been filed.
Okay.
It
has been filed.
So, counsel, since the only thing against you is that you did not regularize, you did not bring the motion to regularize, the court can allow you to orally ask the court to allow you regularize, and the court can do that. The for the clause. So the learned counsel for the claimant filed his consequential amendment out of time, or did not file a motion to regularize the same. The court hereby directs the claimant's counsel to make an oral application for the same, that is for the amendments, for the regularization, so that this matter can proceed today.
Yeah, very good, sir.
Yes.
Lord, motion to the order of this court. Directly striking out the second defendant.
Yes.
The claimant file consequential originating process and reply.
Yes.
Lord, we pray this honorable court.
Come again.
We pray this honorable court to extend the time within which the claimant can file his consequential amendment. We are also praying for an order
Yes.
deeming the already filed special Statement dated 5th day of May 2023 has been properly filed and regular. We are very reasonable court.
Dated when?
It's dated 25th May 2023, my lord.
Yes. Do you have any objection?
No objection, my lord. No objection.
So the application of the council is granted without any objection.
As the
Yes, the consequential amendment of the claimant originating processes in this case, which was filed on the 25th day of May 2023, is hereby deemed to have been properly filed and served. Yes.
My lord, just to further buttress on the purpose of the today's matter.
Yes.
I am aware that the matter is for hearing, but due to the fact that I was hoping that they will have to regularize or probably bring a proper application before the courts. I was not prepared for this.
But the courts are allowed to sometimes allow oral application.
I agree with that, my lord. But I wasn't prepared for this trial. I even spoke with the claimant counsel before this matter was called, that I didn't prepare for this trial, that the trial will not go on.
Okay, how about our starting the trial, and then even if we close today, we allow you another date for cross-examination?
Yes, but my lord, I was looking at checking the processes that exhibit they have to tender, the evidence they have to tender.
No, in this course, if you've been appearing here, you will know that at this point where where documents are tendered and accepted and marked as exhibits, there is no argument or any argument as to the propriety of any document being tendered is deferred to the final written address. It is the way we conduct it here. So whether in fact, you don't have to object to anything. All the documents will go in without prejudice to your right to object. But in your final written address, you can attack any of them.
Yeah, the court places. My lord, I agree with the court, but I wouldn't want to take any step without laying the proper foundation. Also,
Yes.
I observed that the processes that was filed by the Claimant Council, there were no exhibits accompanying those processes. They just filed their statement of facts and the witness statement or notes without uploading, without front loading those documents with the processes that were filed. So subject to
Without
the,
uploading the documents that he will,
just yes,
he will rely upon at the time.
my lord.
In that case, that brings it to another.
My lord,
Which one?
The one that you
No, it's all right.
Okay. No.
Also, if you did not conclude the documents that you intend to rely upon a trial, it is a very major
my lord, sir, what
omission.
was amended was the process, not the document. We do not have any document. All the documents have already been loaded before at the session. The same set of documents. The only thing we just is just the name of the party as this honorable court order. So these documents are not new to them. They are already in the file. They have copies of them. And when my learned friend met me out, I explained to him that it's just for us to take examination. You can come back and take cross-examination at that time. The documents are not new. They are the same documents. They are before the court.
But did you front load them?
Yeah, we front-loaded them when we started this case. But when we filed amendment, we only amended our statement of a claim and all other accompanying processes because the exhibits are still the same. They are still before the honorable court. We did not change anything as regards exhibit.
Let's see.
But we have completed pleading before the broad list of preliminary rejection. We have already achieved a hearing, challenging the decision of court to decide on second defendant. So it's not like the matter is just starting. We have gone a long way.
Counsel,
Hello.
on what so said, it's not as if he just in this case, change his mind about the second defendant, and then now. But he has already gone forward to do one or two things. That is, his matter is already established in court.
My lord, I wouldn't want to put both parties in
Sorry,
situation.
but is there any way at all that you front loaded any documents?
When at the session, my lord, we front-loaded
The exception you did.
when have us their response, front of defense, I will file further, we will file a reply. We have a document that will attach further exhibits. So all these have on them, they are also before this honorable court. They are not new. The only thing that is just removed, my lord, is just the name of the second defendant. Everywhere appear, we take it to Mr. Olu Ajala. That's the only. And they are not documents are about 36. They are 37 all together, including the flash drive. So they have none of these things, my lord.
My lord, in response, I wouldn't want to agree with that because those processes that were filed previously before the consequential amendment have been discountenanced with, like the evidence have gone with it based on my subject to court guidance. They've gone with with those ones. This is a new process.
No, what has gone with that is the name of the second defendant.
Yes.
And anything concerning him.
Yes, my lord. But the way it is, they can't rely on those documents anymore since we have a consequential.
Which documents?
I'm talking about the evidence in those documents, in those processes that they initially filed before the consequential amended statement of fact. They can't rely on that because that is not what is before the court anymore. What is before the court now is the new process that was just filed, and they have to front-load those evidence together with it, subject to the court guidance. That's the procedure. That's the procedure. And we don't want to see a situation where when we get to a particular stage, we now be raising that issue. It's better for parties to put their house in order first before we proceed with the matter. And also the if they even intend to bring flash drive and I don't even have a copy of any flash drive here that I even mentioned. I don't have it. So just not to belabor this court, it's better for the parties to go and put the house in order, then come to the court and go on with the hearing. We can just pray for a short day for parties to put the house in order, then go on with the hearing.
If a learned friend is not ready to proceed to trial, hello. I'm not sure he's getting the concept of consequential amendment. It is not altogether an amendment. It's an amendment that is consequent upon something, what the court ordered. And the court was said that the name of the defendant should be removed as no case has been established against him. The court did not strike this case out. The court did not make all these orders that my learned is talking about. And about the fact that, we serve their office. They have knowledge of this thing. If he's not ready to proceed, he should make an application in that regard. But I know that this virtual hearing is 2021 matters. So this court has very magnanimous with us. But every time I want to proceed, whether they are filing one motion, they are filing PO, this is another case, sir.
All this while I thought this was a brand new case where all these things are just coming up for the first time, like documents to be relied upon at trial. But obviously they are here already. And the mere fact that the defendant is struck off the list does not mean that they have to go and rewrite documents they intend to rely on. That is statement of Temitope. That is this one. Did you change anything in the statement of Temitope? Did you change?
Absolutely.
So the business of the court can still go on. It can still go on.
Okay.
Yes. Okay. Which other matter? I don't know why we should adjourn this.
I'm just okay.
I take it. Counsel, did you itemize all the documents you intend to rely upon at trial?
We listed it.
Where? When? On what date?
On the
Original originating process.
On what date?
That is just a minute.
Just have to check.
It's dated 20th.
List of documents to be relied upon.
It is contained
I've seen
here.
it in my own case file. It's not dated. Then you have the screenshot of the WhatsApp chats.
Yeah, we have it.
Have a copy of the minutes of a minute. This matter can go on. We can go on with this matter. Let us take this evidence in chief. We adjourn. Give you a good adjournment to look through whatever is here. You don't have to do anything about this list of documents because here you cannot argue it now until your final written address.
Even
So,
if I have an objection on the documents.
yes, even if you have another, ask anybody. That is it. People will do it here.
My Lord, I don't know if the Claimant Council will be opposing him. I'll pray the court for a short adjournment. A short adjournment.
The court wants to hear this in chief, and then we adjourn.
Have the copies.
This will give you time to do anything you want to do. Yes.
Have the copies.
Yes, please, and you have to be quick about this.
Very fast. All the documents are.
Yes. So you go on. So have we sworn him? Is this the first time of his of testifying?
I want to.
Is it the first time?
Yes, sir.
He has not testified before.
No, not at all.
Okay. What's his name again? Temitope Sheye. Are you here?
You are muted, Mr. Oguntade.
Yes, I'm unmuted.
Mute
Sorry.
yourself, please.
Yes, I'm
okay.
I'm unmuted.
Are you hearing me?
Yes, I can. Can you hear me?
Yes, you are going to testify in chief.
Okay.
Are you
okay,
a Christian, Muslim, or pagan?
A Christian.
Would you want to swear on the Bible, or you want to affirm?
I don't have a Bible here, but I can affirm.
Okay, then.
That's acceptable. Okay.
Stand up, please. Stand up. Okay, raise your hand. Then your name.
Hi, Temitope Oguntade.
Hereby affirm.
Hereby affirm.
That the evidence I shall give in this case.
That the evidence I shall give in this case.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Okay, please sit down.
Thank you, my lord.
Sorry, my lord.
Okay.
Witness, please tell this court your name, what you do for a living, and your address.
My name is Temitope Oguntade. I'm a software engineer, but at the moment, I'm a student at Carnegie Mellon University.
Okay. Tell the court your address.
Oh, my address is both Carnegie Mellon University in Kigali, and at the moment, right here, I'm physically in Kigali, but also
Tell him that I'm not yet a machine.
Mr. Oguntade, you have to speak slowly.
It's understood.
Saying
sorry, my lord.
Yes. Where do you live?
Yeah, my current physical address is Carnegie Mellon University, Africa in Kigali, Rwanda.
Yes.
That's my current physical address. Carnegie Mellon University, Africa, in Kigali, Rwanda.
Okay.
Can you remember coming to the registry of this honorable court on the 25th day, May 2023, to depose some depositions?
Yes, I do.
On what date?
25th May 2023. You know, it's like
Yes.
want to say something.
Yes.
Apology, my lord.
Yes.
So I spoke with the principal now. He requested for a stand down. He's on his way already.
Okay.
So the other one going on.
Okay. All right.
But I think you can conclude while at least Susan want to come and examine, but you can conclude. Susan has basically nothing to do with the examination in chief, my lord.
Please, I want to say that I don't usually do this.
Apology, my lord. My apology.
This is from my boss.
Apology.
I was going to stop it until I saw the name. I had to listen to it. I'm so sorry. What is my Inka? Please go. Said now you should have told him that if we are going to stand it down, it can't be today again. Look at the time. I said once it's 4 o'clock, I'm alone here. I'm alone. The president called me. After the thing went on. Council, I have to attend this matter, right?
As God pleases. As God pleases.
Give me the shortest date. Give me the shortest date. You said there's another one. I will take that. I will take the other one. My lord is yes. He said I should come.
Let us give me a bit. For the somebody is no, I said I should come tomorrow. We have a meeting on this. How do you stand on this 21st day of May? Yeah, checked. Okay.
23rd is not convenient. It's not convenient. 21st is convenient to me, but you say it's not convenient to you. So 28 is okay. Sorry. 28 is convenient.
Or when? Which is what? 30th of May. That's what-
30th of May. 30th of May is convenient too.
Okay. At this stage. Okay. So at this stage, this matter is now adjourned to the 30th day of May 2025 for continuation of hearing. That
As a
is
couple,
for the continuation of the evidence of CW1.
as a couple, most grateful, my lord. Most grateful.
What is it by
My lord, I wanted to pray to hear pending applications, but we'll take that at the next day then. A pending application for our witness to take his evidence virtually, but we'll do that at the next adjourned date.
Okay.
We'll take that at the next adjourned date.
If you want, if it is a matter for Zoom hearing, the court will never say no.
As
Because
places.
this court is built for Zoom.
As court places.
Yes.
As court places.
Now there's this you are in a matter and you've been here since morning. You must hear this one. Please tell them to put on this. Is it from? Did I hear that you came all the way from Abuja?
We have applied for I could have taken it.
Why didn't you tell me this all this month, all this while? Are you of the church? Are you of the I can't believe it. Okay then, call it up. Please call Yinka for me.
Barrister, can I leave now? Okay.
My Lord, the claimant is present. Which barrister? Barrister.
My lord, sir. As the court please. As the court pleases. 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 I will do that, sir. I will do that. I agree to my lord.
Okay. Okay.
Unfortunately, our clients from the court, my lord, they received the subpoena from the court.
Okay.
Unfortunately, our client is not in the country at the moment. So
Your,
as not
your
to,
client did.
it's not in the country at the moment.
Okay.
So
Okay.
as not to disrespect the court.
Yes.
He briefed us. We came to ask for some sort of indulgence so that we can comply or respond to the subpoena.
Okay.
That's basically why we are here.
Okay.
My lord, the subpoena is to produce documents.
Okay.
I don't know whether the mind of the court would be tilted towards anybody in the organization coming to produce those documents, or whether the party at whose instance the subpoena was applied for would be insisting that the party named on the subpoena must be present in court.
What was the relationship between you and the subpoenaed witness? Okay. What do you say? Yes, I've okay. 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 Okay, Mr.
My lord, if I may.
Mr. Wu, yes.
The subpoena was specific in terms of whom it was addressed to. It was specific in terms of when the person would appear. And it was issued as an instance, but it was issued by the court. So it is personally at
Okay.
at a certain date. It would be disrespectful for the person to just ignore the subpoena if the person were not in this country. And the question of whether who represents the subpoenaed individual or not, I don't think is a matter that is supposed to come up for issue.
Time, and I really would like to get through examination in chief. But rights of audience are afforded to counsel to the parties named in the suit. And as it stands, I only see myself representing the claimant and my learned friend representing the three defendants. At present, we are announcing appearances.
My lord, I am really, really surprised and taken aback at the appearance, because even as at Friday, when the subpoena was served, they called me and we spoke. Even at yesterday, the defendants, from the hotel, Ikeja hotels, they spoke with even the learned sick, and I was no indication that they are sending a lawyer to represent the subpoenaed witness. I am not aware of any arrangement. So,
But subpoena was for
to produce documents, yes. No.
It's,
I don't want to begin to disclose discussions or correspondence between me and with respect to the, but for them to have decided to brief another lawyer to appear for the subpoenaed witness, I am not aware. Maybe when we get to chambers, we'll trash that out.
The court, please. Was for continuation of hearing. My lord, we do have an application first, an unopposed application. On the last hearing date, a couple of our documents thought to have been front-loaded had not gone in. So we simply applied to those documents so that my lord will oblige us to take the application. My lord, the application is dated or was.
Yes, my lord. But then the way my learned friend has put it, that is not really the prayers on the motion paper. The prayers is asking for leave to amend.
Okay.
For leave to amend his pleadings. Yes. So, and there is no pleadings attached. I got back to him that if you want to amend your pleadings, at least there should be a proposal. Let me see what you are amending.
My lord, if I may, it was 8th of March of this year, my lord. My lord, the nature of this application, before we even move it, is such that we had an unlikely scenario where documents listed on our list of documents were not front-loaded, and the court took notice and gave us a hint that we should go ahead and regularize the situation. And so not needing to amend our pleadings per se, but only wishing to have these documents which have already been listed. Filed. Yes, my lord, I was just going to point out that at any rate, there are three reliefs sought on the face of the motion paper. One is asking that the additional documents and exhibits already filed and served be deemed properly filed and served. And another also prays for such further or other this court may deem fit to make under its inherent jurisdiction. As I have earlier mentioned, we have already listed the documents we wish to. It was at the point of trying to tender those documents that this issue came up. And so I undertook to make sure that they were filed before this date. Moreover, my lord, my learned friend has had the full amount of time to respond to this application and has declined to. We're on the 8th day.
But then, have you filed them? What do you have in your hand?
Yes, my lord.
You filed them?
Yes, my lord.
Okay, let me see. Main one or two. So let us now to have this one start with the
Yes, I've responded. Oh my God. My lord, if my learned friend wants to bring in the documents already pleaded, I have no issues with documents, the letters he already pleaded. My lord, I have not seen what he wants to amend. If I want to oppose, I should see what I want to oppose.
My lord, if I may just clarify that particular point. Ordinarily, we would seek leave to amend our list of documents in order to file additional documents. Yes, my lord. However, we are not amending on our list of documents. If my lord, if I would avert my lord's attention to our originating processes. Our list of documents includes 11 documents, number 9 of which is or was not front-loaded, number 10 as well. I did mention on the last date, both documents are documents that the defendants are aware of. Number 10 in particular was responded to by way of number 11, in which they referenced number 10. These are not documents that are new to them. And I do believe that they're just trying to, at this point, it seems, make a mountain out of a molehill. We did consider what the appropriate way would be to introduce these documents and consider that our actual pleadings are intact. All we seek is to include new documents. We didn't want a situation where they might say they haven't seen those documents. And so we attached them to this application.
But what is at stake now? You want to amend your you want to amend your
list of documents.
Okay, you said by filing additional documents.
As the court pleases.
By filing additional documents.
As the court pleases. We didn't seek to make any other amendments to the face of any other pleadings. Yes, but we did consider that those front-loaded documents, by virtue of being accompaniments to our pleadings, require this leave.
I thought you wanted to amend. And then he's talking about concluding other documents. I would have told him, no, why don't you amend
the main things you want to amend. Then you can now just file those ones with front-load your documents. But now, I've seen that what he wants to do is to amend his pleadings by not touching any part of his pleadings, only by filing additional documents.
My lord, that those documents he wants to bring in, at least must be stated somewhere that at this you went to hospital and you were given this, or you paid for this. So to bring, so you will rely on these documents. That is the essence of what he wants to do, to at least mention somewhere in his pleading that these documents, you cannot just throw documents on the court without any reference to your pleadings or to the evidence. You know what he wants to do, that there is no way he can bring in this document without referencing them in his pleadings.
My Lord, again, just to clarify, our pleadings reference all 11 documents listed, including the ones we seek to introduce. If I might remind the court, crystal clear, the last time we were here in January, our learned friend said, I don't see these documents which have been pleaded, and you cannot tender them because I haven't seen them. So my Lord gave us a date, asked us to get our house in order. We did just that. There is nothing that we are introducing afresh. There is nothing that we are asking the courts to look at which has not already been notified in advance to my learned friend.
But has he had a look at all
Filed and served, my Lord. And they've had 7 days prior to today. This is the 8th day, which is why I say this application is unopposed.
My Lord, let's not be going back and forth. If he wants to let his witness adopt or see it as part of his documents, we are not opposed to that. But if he is moving this application for the court to grant an amendment, that is where we have issues. If he says that these documents has been pleaded, that is just to bring them, I have no issues with that. Let your witness, other documents has been admitted. Let your witness also admit it as listed here. Because at the last adjourned date, the issue was they were not front-loaded and they were not before the court. Now, if you said, okay, I have front-loaded them and I want to adopt them, I don't have issues. But if you insist on, you want to amend your pleadings, that's where I have issues. If you want to amend to bring documents, I must see where you are amending, which paragraph you are amending, where are you bringing them? What are the effects? But if you say you have already pleaded them, fine and good. And it will reflect. Yeah.
Now, once the
He's saying that he has pleaded them. So it is because they were not available at the last. Yes. And front load them. And which is, so front loading them does not require amendment.
I think it's a choice of language.
And that's what's affecting us.
That's men.
Yes, that's why he can't. If his application is for amendment of his list of documents to bring additional documents, My Lord, right from the day I received this, I brought it to his attention that you said you want to amend. I have not seen what you want to amend.
My Lord,
I am not taking him by surprise.
We didn't have any such
I told him right from the day I received
we had no such conversation. And I really do think that Learned Counsel is filibustering at this point. The law is quite clear on one point, at the very least, as should you wish to oppose an application, you must file an application in opposition. We gave them sufficient time, sufficient notice. They have not opposed. At any rate, I do not understand the insistence on the mechanism for doing justice. I've always known this court, even conceding perhaps that there might be some flaw in this motion, to always act in the overriding interest of justice. If my learned friend had actually had a look at our application, we have a written address in support. That written address in support lays out the grounds and explains them for making this application. It is an unusual and unlikely scenario where documents which ought to be front-loaded were not front-loaded. I chose not to lay blame at any doorstep and to take responsibility. In order to regularize it, I don't know how, having encountered counsel's resistance in court, I would just go and willy-nilly try to slide a document into the court's file. Instead, we chose to come formally. And in choosing to come formally, the language on the face of the motion paper, as my Lord noted, is not vague. Perhaps new to my learned friend, but not vague. We chose to amend our pleadings by adding documents that have already been pleaded, but not front-loaded. The amendment, so-called, recognizes that this court, by its rules, requires that you must accompany your originating processes with certain features, one of which is your front-loaded processes.
My Lord. Yes, I've looked at it. It's just two sets of documents, the medical and his letter, which are already listed as documents in 9 and 10. My only is the issue of this application. There is nothing to amend. Let the witness adopt his documents. He is, my Lord, even my learned friend, yes, let the witness adopt the documents as his evidence.
I'm supposed to be I'm sure you must have. I have not. So please.
Oh, we are sorry about that.
The application, this is not needed.
It's not needed.
That amendment, you know, you put a lot of things. You add, you subtract, in fact, you substitute, you do all sorts of things in amendment.
But my Lord, if that amendment is granted, invariably or consequentially, there will be consequential amendment, because that is it.
Well, Lord, I have no problem with that. Had we said this 25 minutes ago, we would have had 25 minutes of these proceedings concluded by now. Had my learned friend also said this to me on the phone as he proposed
my Lord,
I would like to finish. I would dearly love to conclude.
I have our chat here.
I would dearly love to conclude.
12th of March.
My Lord,
our
this is highly unfair.
I asked you, what are you amending?
My Lord, this is highly
you said
unfair.
just needed to bring in the documents that were pleaded, but not front-loaded. This is your chat.
And then what did you say after that? Since you insisted speaking, what did you say after that?
So what you told me,
what did you
just
say
to bring them
that,
in?
that correlates with what you've said today in this court? You're filibustering and it's unfair. My lord, I think
I
this
will
is,
not. I will
I
not
am
respond.
also on a flight to Abuja tonight. I've spent 20 minutes arguing something I would have withdrawn 20 minutes ago. And I think that this continued back and forth is unbecoming of anybody at the bar. I came here with a claimant who is all the way in Amsterdam and has been sitting on the phone for 3 hours to indicate that somehow I have insisted on moving an application I need not. This is the second hearing date in a row that he has made allegations as to my intentions and conduct. And now I'm a little riled up.
My lord will bear me witness. I have not insulted him. I have not put anything contrary to the what I am doing professionally.
Remember that gentleman behind is still part of us. No, counsel.
Yes, my lord.
Obviously, this matter, honestly, the courts cannot work in a very tense atmosphere.
As the court pleases.
I've never done, I don't.
As the court pleases.
Now, I don't know how we're going to do this. Mr. I'm going to. Can we come again?
Lord, we have a matter to attend to. If my lord recommends an adjournment, we'll take it.
I would rather we come again and do this in a gentlemanly, guys get, but well, gentlemanly manner. Now, considering we have now I think because we go ahead and say something.
As the court pleases.
Mr. Akpojaro, my lord.
Well, I cannot, I can't say anything about your own case because some people must have trusted you very much to send your user.
Representation, my lord. Yes, my lord. The person, actually, the person subpoenaed. The person subpoenaed. Subpoenaed. The person is not a party in this case. If that is the clarification we are getting from the court, we'll go ahead and comply.
I could say that people give it to the court, even from
Yes, my lord. Yes, my lord.
what we want is the document.
In a situation where the document does not exist, that is also another option that the court wants to think about.
But the document is with you. What did we say?
These documents are Marriott International documents. They are not Ikeja Hotel documents, and they are not Netufo's documents. The party subpoenaed is Mr. Theophilus Netufo. Given the party is chief executive officer of the first defendant, the documents relate to the second defendant's company. So asking him to produce a document that are not in his possession, it's strange.
In other words, it doesn't have.
He may not, I cannot say so, but I would like time to respond appropriately, my lord. As the court pleases.
And, in other words, you just came to explain why that document is
not here today. Why the person is not here today? My brief is short. It's simple.
Not yet because
it's not in the country, and he doesn't want to disrespect the court. Well, I'm most grateful, my lord. As the court pleases.
Lord, I do understand. My Lord, no, the court has in no way stepped out of line or done anything wrong. And I do apologize myself for contributing to the tension in the courtroom. I did not appreciate somebody telling the court they'd had a conversation with me that they hadn't, because we didn't have that conversation. But moreover, my Lord, in terms of the subpoena, like I said, perhaps when we get there, we'll deal with it. If counsel has come to say he's not around, maybe by the next date, they'll have sufficient notice to be around. And I think it's well that my Lord. If my Lord would permit me, I will simply withdraw the application following the direction of the court, and perhaps we can close on that note and take a date.
No, sir, I will not be opposing the application. I will not be opposing the application. Now, I will not be asking for costs. Yes, ma'am.
Lord, Mr. Ewu neglected on this occasion to mention that the cost he asked for before have actually been paid in full. Today, he declined to mention it. Let it be on record, my Lord. I hope so.
So the application of the Seneca to withdraw his is hereby granted. And the motion will notice of the Clemens Council filed on the 8th day of March 2024.
My Lord, I do wonder if any, I say, ruling directive be given with respect to the documents that we sought to bring in, so that we don't have to address it again at any future sitting.
All right.
So we need only just carry on. As the court pleases.
Yes, my Lord.
But I would like to apply to just discharge the witness, even though she was never sworn in. Just to let the witness know that she can log off.
Yeah.
I can hear you. Would you like me to log off?
What time will you go? Maybe I come to praise. Okay, maybe
Thank you.
nothing.
I'm going to get my copy. My flight ticket.
But if you carry
Which one?
the other one sit by 10.
How do you stand on the 21st day of May, according to my registrar?
It's a Friday.
21st day of May.
21st.
Yes, first. 2-1.
Okay.
I mean, 2-1.
21st is convenient, but I also just want to try to plead for an earlier date. I'm back in Lagos on the 19th of April. I was hoping for this.
Okay, now I want to say this. On the date that this matter will come up,
Yes,
unless there is a senior advocate of Nigeria,
yes,
once there is a senior advocate and he finishes his case, I want you, I direct that you get up and remind the court of today, so that your matter will be taken.
I appreciate it.
And you will now be free.
I appreciate it.
It is a direction. It's an order.
I appreciate it.
Please, yes.
As the court, please.
Yes. So you said the 21st is all right?
Yes.
This matter is adjourned to the 21st day of May, 2024 for continuation of hearing of this case. Yes. Thank you.
Thank you,
All
my
right.
lord.
Very well. Mr. Akpojiro, please, if before that time your friend has any information, of course.
No, my lord.
Very well.
We'll make it available. We are responsible citizens of the country to come to court. We are most grateful, my lord.